Alrighty. Good morning. I'm Parole Officer Trisell. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Ikeem Elliott, inmate number 404989. Today is Tuesday, January 21st, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Ikeem Jamal Elliot, 404989.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. And present this morning's attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, public defender with the Parole Revocation Unit, on behalf of Mr. Elliott this morning.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support the violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is also being recorded. Attorney Sirica, is it okay if I swear your client in?
Yes.
All right. So the testimony today will be taken under oath, Mr. Elliott, so can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you. So we're going to go over the procedure for the hearing. So first I'm going to read you your rights. We're then going to review the parole violation charges that the state, your parole officer, is bringing against you. I will then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. And after considering all the evidence presented, I'll announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you do have important rights for this hearing, and the first is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, ma'am.
So you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine any voluntary witnesses and to cross-examine adverse witnesses. Do you understand all these rights, and are you ready to go forward?
Yes, ma'am.
Okay. So we're going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of obedience to the law, the charging officer reported that on November 2nd, 2024, you pulled alongside the victim in the car she was riding in. The victim immediately recognized you as her ex-boyfriend and stated you had a threatening expression. The driver of the victim's vehicle informed the victim that you had a firearm, and the driver told her to get out of the vehicle. When the victim exited the vehicle, she heard 2 gunshots go off. The victim then fled to the train tracks to hide. Upon police arriving to the scene, police recovered 1 9mm shell casing, and you were subsequently charged with breach of peace second, 53A-181. The state has filed the following exhibits that have been pre-marked for identification purposes as Exhibit A, the remand to custody order, Exhibit B, the parole conditions, Exhibit C, the parole violation report, Exhibit D, the notice of parole violation, and Exhibit E, the Waterbury Police Department CFS number 24001043326. And the state has also filed an addendum to the parole violation report, which is also taken in as evidence on December 16th, 2024, and it reads as followed. On December 13th, 2024, Elliott Ikeem number 404989 was sentenced on docket U04W-CR24-0511612S. He appeared on charge 53A-181 breach of peace second, received 6 months jail, execution suspended, conditional discharge 1 year. Please proceed with the revocation hearing. Attorney Sirica, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes.
Perfect. And I did receive a defense exhibit, just exhibit 1, a list of parole accomplishments and future plans for parole reinstatement.
Yes.
Do you guys need any additional time to submit any other evidence?
No.
Okay, so we do not have any witnesses today, and the state is not here, so it is now the defense's opportunity to call any witnesses, present evidence, and speak to the charges and the evidence submitted.
Yes. Regarding that charge number 1 under obedience to the law, my client vehemently denies this is the way the incident occurred. Here's the problem with Mr. Elliott. He is on special parole supervision, and he was arrested for this incident. And obviously he can't post a bond because there's a parole remand. So with the help of his attorney, he did dispose of the case. Because otherwise, in order to have a trial on this, he'd be sent in jail because of the parole remand. And as you can see from the disposition, that is the correct addendum. My client received a 6-month execution suspended, which means no jail time, and a 1-year conditional discharge. If this really happened the way it did, where there was actual gunshots fired, I highly doubt the prosecutor would have made a offer of a conditional discharge with a suspended sentence. And I may add, I understand it's Mr. Elliott who is here on the parole violation and not the alleged victim in this case. And I won't put her name on the record, but I think this is fair game. Her initials are AC. And prior to my client being accused of these charges on where he was arrested on November 2nd, 2024, in the parole violation report, which is exhibit, I have it listed as exhibit C. On the bottom of the first page, where the narrative of the parole officer was contacted that my client was allegedly involved in this incident, she reached out to Mr. Elliott, and my client did report to the Waterbury Police Department and speak to them, and then he was later charged with breach of peace. Now, what's even more important is the following paragraph, where it should be noted that Mr. Elliott and the victim have an active protective order resulting from an incident on October 2nd of 2024 at Library Park in Waterbury. Mr. Elliott, my client, is the protected party in this incident on October 2nd of 2024. She was the perpetrator. She pushed Mr. Elliott and swung at him. This was also caught on video surveillance. How ironic that my client is the victim, actually, exactly 1 month prior to this incident taking place. So my client gets arrested for this incident and is being held because of the parole remand. And if I may, the quote unquote alleged victim in this incident, who was the perpetrator in the other incident against my client, has 2 outstanding warrants for her arrest. And here's proof from the JS for not going to court from the incident that occurred on October 2nd of 2020. So I just checked this morning prior to this hearing. This so-called alleged victim in my client's case has 2 warrants out for her arrest. It's just ironic how a month prior to where my client is a victim, and it's not Mr. Elliott making this up. This is from the parole violation where it indicates when my client was the victim and she swung at him, and it's all on video surveillance. And then exactly a month later, there's an allegation that my client fired 2 shots, which is very bogus. But like I said, I understand he pled in court, but his back was, pardon the analogy, up against the wall, because if he had asked for a trial, which he originally is going to be sitting in jail for months before they actually conducted a trial for my client. So that's the reason why he disposed of it the way he did. So I don't have any further comments regarding the disposition. I do want to be heard about his background. I know you're going to make a finding. There's a disposition in court. I'm okay with that. But I just wanted to paint the picture here of the so-called victim in this case. She is the victim in this case, but it's very important to know the history, what happened a month prior to where my client was a victim, and it's caught on video surveillance. And here we go, a month later, she makes these bogus allegations, in my opinion. I understand, once again, I know there was a plea in court. It was under the Alfred doctrine. I'm not sure, if you're familiar with that. It just means my client pled guilty. He didn't agree with everything that's in the police report. That this incident occurred, but in order to get rid of the charge, he did take a plea under the Alfred doctrine. Thank you.
Thank you. And I'll let you know my findings. So on charge number one, Mr. Elliott, I do find that you violated the condition of obedience to law based on your conviction of breach of peace second, General Statute 53A-181 on December 13, 2024, when you were sentenced to 6 months jail, execution suspended, and 1 year of conditional discharge. In addition, the following evidence supports the charge, and that's Exhibit B, Exhibit C, and Exhibit E. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, you will have the opportunity to speak to your background history and any other pertinent information at this point. So counsel, would you like to make a statement?
Yes, on behalf of Mr. Elliott, I am respectfully requesting to have my client reinstated as soon as possible for a couple of reasons. One, being the disposition from court, he did not receive any jail time. It was a conditional discharge. That kind of tells us how serious the state thought the charge was. Also, the parole officer recommended complete any sentence imposed by the court. That's also been accomplished, in my opinion. My client is 29 years old. He does have 2 children. Upon his previous release, he did successfully complete the Connecticut Renaissance Halfway House in Waterbury. He did have a full-time job at Platt Livonia in Waterbury. He was doing hazmat spray painting. It was promoted to welding, then painting. He was there for approximately 8 months. So it was a good stretch of time where he worked there. Also, does some side work delivering for Uber. And also did hair cutting and braiding of the hair. He came to us, just successfully complete the anger management and one more behavioral health in Waterbury. Also, did speak to the youth at the recreation center from the Reach Apartment in Waterbury. Did that about twice a month. So engaged in the community. He liked bees as far as housing. Upon reinstatement, he's amenable to being placed in a halfway house or the connection reentry assisted community housing in the Reach in any available jurisdiction. And somewhere down the road, he has to go to the process. He'd like to move back to North Carolina, and he does want to enroll in trade school to study welding. He's indicated to us he's able to return to his full-time job at that Platt Livonia company. Ikeem, anything I left out about your background, what the plans are for when you get out?
No, it's just a lot of things that you say. It's like you really did your research, and it's like, when I went out in the community, I didn't, even in the halfway house, the REACH program, I never gave anybody any dirty urines. I never got in any type of trouble. I never did anything. Only thing that happened that night was when I was doing Uber eating and I seen the victim. Only thing what happened was she seen me in the car with my wife and she got mad. I have a whole wife and she lives in New York. So I was cheating on my wife. And when she seen me with my wife, when I was doing Uber eating, she just went ballistic and she went crazy. But prior to that, before when we was in the park in Waterbury, when we was by the library, she had my wallet. So she took my wallet and I never had my wallet back. And she was been promising to give me my wallet back. I never done anything to her. I took care of her. I took care of her and her daughter, like I was supposed to go get on her birth certificate. It's just crazy that I went and turned myself in. Most people, as soon as my parole officer called me and said, Mr. Elliott, go turn your police detectives want to talk to you. I asked her one question only. I said, Miss, are they going to lock me up? Anybody else could have ran. Anybody else could have did anything. I had 375 acres of farmland down south. I'm trying to get back home to do what I got to do for my family that's back in North Carolina. And it's like, it's crazy that one little lie could jeopardize everything, and I messed up. I messed up. It is nobody's fault but mine. I blame myself. But I could have thought just because people would see that by my violent history in prison and my violent history outside of prison. Before I went to prison, like I didn't go home, I didn't think about no drugs, I didn't think about no guns, I didn't think about none of this. So it's crazy that one person could say, oh, he had a firearm, knowing that I'm not supposed to be around any firearms. You get what I'm trying to say?
I'm sorry
for
for
cutting
your
you off.
comments. No. And you're not charged with anything else, Ikeem, but this obedience to the law. Like you said, I had to do as your attorney, that is my job to do further research. And that's why I had to bring that additional information.
Everything you said was correct. That's crazy.
Correct. I have documents to back up what I put on the record. I don't just, say things. I have paperwork to back up what I put on the record. Okay.
My public defender in court, she said, Mr. Elliott, this is some bogus shit here. She said it just like that. She said, this is bogus. If you was to wait on trial, 2 years the most, you have to be waiting in jail. I'm just plead out to it. It's nothing. It ain't nothing I haven't been through. It's the waiting process of, what I was doing when I was out there. You know what I'm saying? But
thank you for your comments, and we'll take care of this. Thank you.
So I'm just gonna take a moment. I'll let you know my recommendation. Okay, so I did listen to your testimony. I do appreciate your statements and comments, and I have reviewed all the evidence. So based on that, I am going to recommend your parole be revoked and you serve an approximate 3-month sanction. And that's with the reparole date of February 2nd, 2025. In addition to that, I'm going to recommend the following conditions: behavioral management program for anger management. You said you completed it, so if you did, you can work with your parole officer if you have completed it. No contact with co-defendant Kjuan Weaver, a general no contact with AC. Halfway house placement. I know you said you're open to any location. Do you have anything specific? Maybe
Any part of the state I keep
Waterbury is not beneficial. Maybe you want to try somewhere else.
Either Hartford or New Haven.
I'm gonna do Hartford first. Is that better for work purposes? Because you did say you were working full time. You can get back into it. Yeah, so
I got family out there.
So Hartford's okay. And those are all of my recommendations. They're going to go to the board on January 30th. And on that date, the board is going to decide whether they are going to adopt my recommendation. They can give you a lower date, but they're only playing with a few days at that point. Or they can, they could do a supplemental hearing for if they want to keep you in longer than that. Okay. And if that happens, you'll be notified. There'll be a separate hearing. You'll be addressing their questions and concerns.
You said
Right,
for 3 months.
3 months. So it's February 2nd is the date of 3 months. That is a weekend FYI. So normally it's the day before.
Yes, and you're on special parole, Ikeem. So if the board adopts the recommendation on the 30th, they have to release you on February 2nd.
Okay.
If there's an issue with them not adopting it, the recommendation, I'll set up another call with you. Hopefully.
How would I know that?
They'll release you that day. That's how you're gonna know if they adopt it or not. Or actually, if you call our office on, give me 1 second. We get an email before we get it in writing. Give me 1 second. Call our office on Friday, January 31st, and just give them your name and tell them you had a board review the day first. What was the outcome? One of my secretaries can give you the information over the phone.
All right, appreciate that.
Okay, good luck to you.
Thank you.
This concludes the hearing for Ikeem, inmate number 404989. Thank you, Mr. Elliott. Good luck to you, okay?
Thank you. Thank you. Thank you. Back.
Hi, Officer Carrington, how are you?
Good morning. I'm good. How are you?
Good, thanks. So ideally, we're still gonna start at 10. We're just having issues with the 9:30 person. So
Okay.
hopefully we're on time, okay?
All right. I'm here. Thank you.
All right, thank you.
Oh, maybe it's working. Oh, there you go. It's working.
Is the mic on?
So the mic's on, we can hear you. We just can't see you. Do you see,
Yeah, I see you guys.
you see us? We can't. Go ahead, Kristen.
Thank you. On your tablet, do you see the video icon and the microphone icon that should be touchscreen buttons?
I'm pressing them. It's not working.
Okay, because the video one might have a slash through it.
Yeah, it's not working.
The screen's not touchscreen?
The tablet, not the television.
Yeah, I know.
Yeah.
Pressing
What
it.
about this thing right here? Does it have a microphone on it? The thing you hit for
Yeah, this does too.
right
You can hear us, right?
Yeah, we can hear you.
Yeah.
It should have a camera on there.
No, it doesn't.
Do you see the camera icon though?
Yeah, but it's not working when you press it.
Does it have a slash through it or is it gray?
Slashed. Nope, it's slashed gray.
Well, okay, so it has a slash and it's gray.
Yeah.
Okay. So usually if it's gray,
It
it
says
means
select. Oh, wait, hold on. Let me see if this works. Oh, there you go. Is it working?
Got
Yeah.
it. There you go. Perfect. Thank you so much.
Yep.
Okay. Good morning, Mr. Howard, correct?
Yes, ma'am.
Awesome. So good morning. I'm Parole Officer Trisella. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Christopher Howard, inmate number 339747. Today is Tuesday, January 21st, 2025. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Cheshire Correctional Institution. Can you please state your full name and inmate number for the record, please?
Christopher Howard, number 339747.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. And present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Howard.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and that this hearing is being recorded. The testimony at today's hearing will be taken under oath, so Mr. Howard, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
So we're going to go over the procedure for the hearing. First, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We will then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my finding. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose of the procedure before we begin?
Do not.
You do have important rights for this hearing, and the first is that you have the right to be represented by an attorney, and counsel is here present for you. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yeah, shortly after we spoke the first time.
Okay, perfect. And you were able to review that notice as well?
Yeah, some of it, I don't remember any, like a lot of it, I don't even remember it happened.
Okay, yeah, we're gonna go through it all again. That's okay though, so as long as you reviewed it. You also have the right to review the evidence before this hearing. You also have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine any adverse witnesses. Do you understand all these rights, and are you ready to go forward?
Yes.
So we're going to review the charges that the state your parole officer is bringing against you and the underlying information for each charge. So on charge number 1, condition of GPS, the charging officer reported that on November 15, 2024, you failed to properly charge your GPS unit, resulting in the device shutdown from 2:01 p.m. to 2:54 p.m. Your actions are in violation of your signed GPS agreement. For charge number 2, condition of drugs, the charging officer reported that on or around 11/14/24, you used cocaine, and on or around 11/15/2024, you used cocaine and an opiate. In charge number 3, condition of halfway house placement, the charging officer reported that on November 7, 2024, you were allowed an authorized drop-off by Eddy Center halfway house upon your arrival to the halfway house. During the drop-off, you were extremely rude and were yelling at the drop-off person to shut up. The interaction between you and the drop-off person was so disrupted, the halfway house staff had to intervene and end the drop-off. And then on November 15, 2024, you were found in possession of a used crack pipe at Eddy Center halfway house. Your actions are in violation of Eddy Center halfway house rules, which prohibits the possession of drug paraphernalia and lists such item as contraband. The evidence that was submitted was identified at the preliminary hearing, and those all remain the same, and I have not received any additional evidence from PCS. So, counsel, did you and your client receive the notice, the parole violation report, and all the other documents?
We did.
And I did receive an exhibit from the defense, and that's exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you and your client need any time to submit any additional evidence?
No.
So today we do not have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and to speak to any of the charges.
Yes, if I may, it appears here a preliminary hearing was conducted, it looks like on December 3rd of 2024, prior to Mr. Howard having representation. And I do have a copy of the preliminary hearing summary where findings were made on those charges. So it's going to briefly touch upon some of these charges. Christopher, on charge number 1, I know at the preliminary hearing, it looks like there was just a singular 1 count of the GPS, and it looks like my math is correct, approximately 44-minute shutdown on November 15th of 2024. Do you recall if on that date the GPS, when it shuts down, I believe it vibrates or light goes off, did anything occur while?
It wasn't,
It was
when it usually that's when I plugged it in is when it vibrated. It didn't vibrate.
Okay, so on that day, that 44-minute shutdown, you didn't get any
I don't
notification?
recall it vibrating.
Okay, and that's why I want to put on the record regarding that charge number 1. Now, charge number 2 is I spoke to you via telephone, Christopher. You have a drug issue, correct? You're not attempting to hide that. Okay, and that kind of plays out in charge number 3. The November 15th incident, was there an overdose situation on that particular day, if you recall?
I don't recall like what led up to it. I just know I was told I came to.
Okay.
They said they found me convulsing. I heard 2 different stories from them.
Okay, all right. And do you recall making comments that you used on that day, but that you did indicate, I believe, at that the crack pipe was not yours, correct?
I did use cocaine, but I didn't smoke.
Okay, and I believe that's.
I didn't intentionally use an opiate. It was something in.
Correct.
I've never had an opiate addiction.
Okay, I appreciate your comments. And the other part there, Chris, on November 7th, I know there's an allegation that you were being extremely rude and were yelling. Did you yell at anyone that day?
I did not. I did tell her to shut up, though.
Correct. You did use that phrase, shut up, but you
I said shut up. I didn't say shut the F up. I didn't say
Yeah.
anything like that. I was not yelling. The staff came out of the office yelling at me saying that it's not okay to disrespect a woman, which I didn't. I said, shut up. Because she was going off on a tangent, which she does. And before it got to that point, I said, shut up. Yes, it was inappropriate. But at the end of the day, I mean, different people handle things differently. Shut up to me is not that disrespectful. Especially, I've known the person 15 years. She knows shut up isn't really me being disrespectful to her other than just saying, you know, shut up.
fair enough. And Chris, I know
And if you look at the camera, you won't even see me yelling at her.
And Chris, I know it's a brief period of time. These are some quote unquote technical violation. You didn't pick up any new charges while you were out. There's no arrest warrants, no court dates anywhere, correct?
No, and I don't intend on ever having any new charges.
Thank you. That's all I have. I just, like I said, he did go forward on his own on December 3rd. Just wanted to clarify some of after speaking to my client specifically for the GPS there. Also, like I said, it appears it's one singular issue during that brief period of time. I don't think he's had any issues with that. As he indicated, it appears the unit did not vibrate. So it was a 44-minute span where he didn't even know that the unit had shut down.
Thank you. Just gonna take a moment. I'll let you know my findings. Okay, so I'm going to make my findings. So on charge number 1, I do find that you violated the condition of GPS based on the evidence provided in Exhibit B, D, F, and J. On charge number 2, I find that you violated the condition of drugs based on state's Exhibits B, D, I, K, and L. And on charge number 3, I find that you violated the condition of halfway house placement based on state's Exhibits B, D, E, G, H, K, N, O, I, N. Okay, I said K twice. Did it be K twice? All right.
Yeah, you said K twice.
Yeah.
Did it say K twice, right? Okay, so just K.
That's okay.
Well, sorry about that. So those are my findings. And that does conclude the fact-finding portion of the hearing. Before I make my recommendation, you will now have the opportunity to speak to your background, your history, any information you want to provide. So counsel, would you like to make a statement?
Yes, on behalf of Mr. Howard, my client, he's 35 years old. He does have 2 children. Unfortunately, his self-admitted here on the record, does suffer from a severe substance abuse issue. Thankfully, as we put on a record, he did not pick up any new charges. These are technical violations, but at the end of the day, they're violations. He has previously completed the timeout program. It looks like in February of 2024. He did report to us, he did receive a culinary certificate while at Osborn Correctional Institution in the past. Did work previously seasonally at Macy's Logistics in Cheshire, as well as McDonald's in Waterbury. And while he was at the Eddy Center, he was out searching for employment. He was given a proper pass to go out in the community to look for work. He does previously has received some services from TMIS, and then also some individual therapy from Connecticut Renaissance in Waterbury. He did do the initial intake for the Explorer program also. He is, as far as housing, he is amenable to being placed in a halfway house aside from Renaissance in Waterbury. He's reported to us he's had previous success at both the Chase Center and the Bishop House, and he does ultimately have a sponsor, Mr. Howard, like to be sponsored. It's a Miss Sherry Plouffe. I did provide you with an ad. I know we're not there yet, but that's his Chris's ultimate goal, and he's amenable to any job opportunities and any treatment he needs to do. Christopher, anything you want to add about your background or anything as far as treatment when you get out, so you can get yourself back on track?
I just need a drug, some kind of drug thing. Almost died this time.
I know, I read the report, and I'm glad you're admitting it, and hopefully, once you get reinstated with the help of your parole officer.
I probably wouldn't be admitting it if I didn't almost die.
Thank you for your comments.
Yeah, thank you, Mr. Howard. So I'm just gonna take a moment, I'll let you know my recommendation. So I have listened to the testimony and the evidence, and I reviewed all the evidence presented. Based on that, I am going to recommend your parole be revoked, Mr. Howard, and I am going to recommend a 5-month sanction. That's with the re-parole date of April 16th, 2025. In addition, I'm going to recommend the following conditions: no alcoholic beverage consumption, behavioral management for domestic violence, no contact with the victim RJ, and mental health evaluation. I do have halfway house placement. I'll do that for a backup plan. Who is Miss Clute? Sorry.
She is a friend of mine.
Just a friend? Okay.
She's kind of been a mother figure for a while. She yells at me and smacks me upside the head a couple of times when I'm doing stupid stuff.
Okay, so you would like that as your first choice, so we'll put her in as a sponsor?
Yes,
or would
but
you
if it
rather
doesn't
go to the
work
halfway
out, I
house?
would like to go to Waterbury
Waterbury
for
for
a
the
halfway
halfway.
house.
All right, so we'll try her out first. Okay, and that is my recommendation. It's going to go to the board on January 30th, 2025. And at that hearing, the board can either adopt my recommendation, they can lessen it, or they can actually do a sanction higher than what I've recommended. If that
You
is the
said
case.
April something?
16.
16.
Okay, so if they choose to go longer than what I have recommended, you'll be notified of a supplemental hearing that's going to be held, and you'll be present to answer their concerns and questions, okay? Do you have any questions?
What are the reasons they usually proceed to higher sanctions?
It's on case by case situation, Christopher, and what I can tell you, in 5.5 years, I've had 2 supplemental hearings, and both of them were on.
I've listened to like 2 of them, and every time I listen to them, it seems like all they do is say, "This is what they said." I hear a bunch of I.
Mr. Howard, you've also been through this quite a few times, so I'm sure.
That's why I meant. Christopher, call our office on January 31st, which is the day after your board review date. One of my secretaries can let you know over the phone before we get it in writing if the board adopted the recommendation.
So it's going to be the 30th.
Correct. And I'm telling you, call our office on January 31st after 11 a.m. and I will be able to tell you over the telephone whether you're getting out on April 16th or not. Okay, let's do that. All right. Good luck to you.
This concludes the
Thank you.
revocation hearing for Christopher Howard.
And you did say January 30th is the hearing?
Yes, sir.
Yep.
All right.
Perfect. Thanks, Mr. Howard. Good luck.
Sorry.
Have a good one.
I have Mr. Vasquez here too.
Oh, that's for Officer Saunders. I think that they're going to start at 10. She's going to be sending in another request for you guys to join because she's in a different office. I think Kristen,
Yeah.
are you the
I'm listening, yeah. So we just have 2 hearings going on today, so that'll be a call that comes in from the other room.
Okay, so you want me to end this one?
Yeah, you can end it, I can hang up, but just as long as you
Okay.
know, in a couple minutes, we'll send you the new call.
Thank you very much.
Thank you.
Kristen. Can you hear me?
Yes.
So I just spoke with the lieutenant at MacDougall, and he said that they're with the understanding that today's hearing was canceled. Per a supervisor who he forwarded me to and didn't answer the phone, so I left a message for her.
Are
How
you
do you
gonna
feel?
still try to get Mr. Brown down if you can?
I'm gonna attempt it.
Okay.
Yeah. So obviously you have not received any communication from them, correct?
I have not.
Should I go talk to DICOM? All right, I'm gonna mute you now. I'll come out and talk to you.
Okay.
Thanks. Oh, Officer Carrington, I totally forgot about you. Are you there?
I'm here.
I don't know. You did not hear anything, did you? Was I muted the whole time?
No, I didn't hear anything. You were muted.
Oh, okay. So MacDougall decided to cancel our hearing because they just wanted to. So I just got off the phone with them. We're going to do it at 11:30. Is that okay? Does that work for you?
Sure, I'll log back
Okay.
in.
Yeah, whatever works. If you want to stay, like you're more than welcome. Obviously, just muted. But yeah, we'll see him at 11:30. Thank you so much. I appreciate it.
Thank
All right.
you.
Just come have a seat right here.
Agentis, how are you?
Are you good yourself?
Good. So I think we're with you. Yep, just for Mr. Camacho. So we're all set. Mr. Camacho, we'll start. We have to wait until exactly 10:30, so we have about 6 minutes, okay?
All right.
All right, thanks.
All right, police officers, raise your hand.
Good morning, I'm Parole Officer Trisell, and I'm a hearing examiner at the Board of Pardons and Paroles. And this is a revocation hearing concerning Alexander Camacho, inmate number 314162. Today is Tuesday, January 21st, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Alexander Camacho, 314162.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Sienna Dean from the Parole Revocation Unit on behalf of Mr. Camacho. Good morning, sir.
Morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you, and the state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that the revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Camacho, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. So first, we're going to go over the procedure for the hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you'll have an opportunity to present any relevant testimony and any relevant documents. And after considering all the evidence presented, I will make a finding. I will make my finding. And after, if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, don't.
Okay, so you do have important rights for this hearing, and the first is you have the right to be represented by an attorney, and counsel's here present for you. You also have the right to receive a written notice of the charges of violation. Did you receive the written notice?
I did.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call witnesses and also cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do.
So we're going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, condition of drugs, the charging officer reported that on 11/14/2024, you submitted a urine sample that returned from Premier Biotech Lab positive for cocaine. You denied use. On 11/26/24, you signed a voluntary admission to cocaine use on the previous night. The evidence submitted by the state, I don't know if I identified it. I'm going to identify the evidence just to put it on the record. So the state has submitted the following evidence: Exhibit A, the parole violation notice; Exhibit B, the romantic custody; Exhibit C, the parole violation report; Exhibit D, the signed parole conditions; Exhibit E, the Premier Biotech Lab results from 11/14/24 sample; Exhibit F, the voluntary admission signed on 11/26/24. And in addition, since the preliminary hearing, they've also submitted 2 additional exhibits, and I'm identifying them as Exhibit G, the timeout program discharge report, and Exhibit H, the disciplinary report dated 11/20/2024. The state has also filed an addendum to the parole violation notice on December 30th, 2024, which is also being admitted. And reads as follows. On 11/20/2024, Mr. Camacho received a Class A disciplinary report for intoxication while in the timeout program. The report indicates that Mr. Camacho submitted a urine sample that was positive for Suboxone and signed a voluntary admission. Mr. Camacho signed a guilty plea to this DR on 12/23/24. Mr. Camacho was discharged unsuccessfully from the timeout program and will need to proceed with a full revocation hearing. Attorney Dean, did you and your client receive all of the evidence that have been identified as well as the addendum?
Yes.
Great. And I did receive an exhibit from you, correct?
Yes.
I have just one, Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Correct. All right. Do you need any additional time to submit any other evidence?
I do not.
So then at this time, we do not have any witnesses, so it is the defense's opportunity to call any witnesses, present evidence, and to speak on the charges.
Yes, thank you very much. So for the charge of drugs, I just want to note this is, a difficult situation, very unfortunate. My client is someone who struggled for a good portion of his life with significant addiction, and he did experience a relapse, unfortunately, while he was out in the community. However, he really does want more for himself, and it appears he was asking for that help while he was in the community. While he was there, it appears that him and his PO were trying to work together to come up with a plan for his recovery going forward. He had contacted Recovery 12 Sober House. That was considered in November when he met with his PO. However, when he went there, he was having difficulties. I believe his mental health may have not been in the best place. He got in the hospital. When he returned, they were unable to admit him. And so unfortunately, there weren't other appropriate placements in the community for him at that time, and that he was remanded. But I do think it's important to note that coming out of incarceration from his most recent release in early November, he unfortunately was in a position where he didn't have any sort of ID. DOC didn't provide him with that. So he did try and get started with, getting himself off on the best note, getting into IOP and SCAT, but was unable to do so because of that ID issue. And as to the addendum, I do think it's important to note Mr. Camacho does have a history of benefiting from medically assisted treatment, specifically through Suboxone. He is someone who has struggled with addiction for a while, and he can experience withdrawal-like symptoms when he isn't on something like that. So I just want to note that in this situation, I don't think this was a situation where my client was, intentionally trying to abuse substances while incarcerated. I think it rather was something where, he does have that prior experience going forward with the medication-assisted treatment, and he does experience those withdrawal-like symptoms without that. Nevertheless, I understand, it's an unfortunate situation. Drugs at jail, it is difficult that there's, people who suffer with substance use trying to get clean in jail. And then, there are things present there, just like there are on the streets. Thank you.
Thank you. So I'm just going to take a moment. So for charge number 1, condition of drugs, I am going to make a finding that he violated the condition based on the evidence in support of the charge, which is Exhibit C, D, E, and F. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you will have the opportunity to speak to your background, history, any information you would like to provide. So, Attorney Dean, would you like to make a statement?
Yes. My client, Mr. Camacho, is 37 years old. He was born and raised in Puerto Rico before he moved to Connecticut as a child. Most recently, while he was on special parole, he was sponsored by his then girlfriend, Miss Scallop, in London. Prior to his most recent remand, he had met with staff at Recovery 12 Sober House to try and get a placement there. He previously had utilized that program from September of 2021 until April of 2024. My office reached out to them and did get documentation where they really were just singing his praises and saying wonderful things about him. They confirmed that during his almost 3 years there, he successfully passed all random drug screens. He was continuously employed full-time. He was a model citizen in the community. He attended meetings on a regular basis, complied with all rules and anything asked with him. And they said that he was a very positive member of that community and helped other people with their sobriety who were around him. He's worked a number of jobs in the New London area while on parole, including Burger King, Smash Burger, A1 Home Improvement, and Greg Gardner Construction. Most recently, he was employed full-time at Airtime Landscaping out of New London and reportedly started this position when he was released and had worked there on and off previously. While he was released on special parole in November of 2024, he was trying to get into outpatient treatment, but unfortunately, as I had mentioned, he didn't have IDs upon release, and so that presented some difficulty. While he was released on special parole in November 2024, I had noted that he had tried getting into the IOP program at SCAD. Previously, while on parole, he did treatment at Act Foundation successfully from July to September 2021. He also engaged in anger management there. After completing ACT, he reports that he then did IOP, outpatient treatment, and successfully completed that in December of 2021. He was doing medication-assisted treatment in the form of Suboxone at Community Health Center in New London. From March 31st to April 3rd of this past year, 2024, he also completed detox at SCAT, which he personally tried to get into that treatment himself. I don't believe that was, required of him. His primary care services are established in Community Health Center along with his medication-assisted treatment. While on parole, he was on a minimum contact schedule with a good regularity of contact. Since his incarceration, he had completed approximately 1 month of the timeout program, and he has been attending 12-step meetings, AA and NA, twice a week on Mondays and Fridays. On having his special parole reinstated, my client would like to be placed in Recovery 12 Sober House, and he has been working while incarcerated with them to try and see about a placement there. He reports that he's been in contact with the house manager, Miss Ortega, who is holding a bed for him at this time. He is also hoping to return to a full-time position with Airtime Landscaping, and he's open to any sort of treatment suggested, including IOP, 12-step meetings, and is also hoping to utilize CCAR for additional support in the community. I would just ask that my client be given the soonest possible re-parole date so that he can continue his journey to recovery in the community. He's put in a lot of effort, I think, while incarcerated to come up with a plan to set him up for success going forward in the community, which includes a combination of sober housing, 12-step meetings, IOP, and medication-assisted treatment. And I feel that if all of those things are set up for him, he will be successful. So I would just ask for his soonest release based on all of that. Thank you very much.
Thank you. Just want to take a moment. I'll let you know my recommendation. So I have listened to the testimony. I've reviewed all the evidence provided. Based on that, I am going to recommend your parole be revoked, Mr. Camacho, and that you serve an approximate, we'll do 3-month period of confinement with a re-parole date of February 27th, 2025. In addition to that recommendation, I'm going to recommend the following conditions: no alcoholic beverage consumption, behavioral management program for anger management, no contact with the co-defendant Leslie Vasquez, no contact with the victims MM and RW, a general no contact with CVS Pharmacy at 817 Bank Street in New London, Connecticut, mental health evaluation. I am going to make note of the sober house that you're interested or that you've been working with, but I'm also going to do a halfway house placement just in case for a backup plan. If they have to get you out into a bed somewhere, okay? So those are my recommendations. They're going to go to the board on January 30th, 2025. And at that hearing, the board can either adopt my recommendation, they can lessen it, or they can request a supplemental hearing because they would like to speak with you more because they're looking to do a sanction greater than what I'm recommending, okay? So if that's their decision, you'll be notified of that hearing. You'll be there to answer their questions, concerns, whatever it is. But on the 30th, they will decide what they want to do with my recommendation, okay?
All right.
So if you want to contact my office after the 30th, Mr. Camacho, I can let you know what they decide, okay?
The 30th for this month, right?
Yeah,
That's
January 30th, yes.
Okay, all right.
All right, thank you very much, sir.
All right, you too. You have a good day.
So this
Take care.
is the final revocation for Alexander Camacho, MA number 314162. Hi, Officer Davis, are you with us?
Officer Davis, you can press *6 to unmute on your phone.
Yes, I'm here.
Okay, great, thank you. We're just trying to get in touch with Osborn.
Do you want me to, I can do it on the phone? Oh, I have the team. Do you want me to do it on the phone or with Teams, or does it not matter?
It's 100% your call.
I'll just do it on the phone since I got you. I'm on the phone right now.
All right, no problem. So yeah, once we connect with Osborn, we'll start at 11 o'clock, okay? There we go. All right, perfect. Hello, good morning.
Good morning. He's just coming through the gate right now. He should be here about 20 seconds.
Perfect, thank you so much.
Thank you.
I can do it. Got this prelim start right now.
No problem.
Richardson, check it for
Okay, no problem. Yeah.
Can you go help? Lawrence just needs help with something. Do you mind?
Okay.
Thank you. Yeah, she just needs help looking at something.
How's it going?
Good morning, Mr. Gardner, how are you?
I'm good.
So we're gonna get started now. Can you hear me okay?
Yes, ma'am.
Okay, perfect. So I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Mark Gardner, inmate number 374513. Today is Tuesday, January 21st, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Mark Gardner, 374513.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Parole Officer Davis. Officer Davis, can you please identify yourself for the record?
Yes, Parole Officer Davis, Hartford
Thank
District
you.
Office.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the condition of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there's a probable cause to believe that you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and that this hearing is being recorded. The testimony at today's hearing will be taken under oath. So Mr. Gardner and Officer Davis, can you both please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Yes, I do.
Thank you. So we're going to go over the procedure for the hearing. First is I will read your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. I will then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you do have important rights at this hearing, and I just want to review them with you now. So the first right you have is that you have the right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney can represent you at this hearing?
Not really. I didn't.
Okay. Would you like to seek counsel for this hearing?
No, ma'am.
Okay, so just to confirm, you're okay with moving forward today without any legal representation?
Yes, sure.
Okay, great. Because you do have pending charges, correct?
Yes.
Okay, so I just want to then one more time remind you, anything you say at this hearing can be used against you. It is an adversarial proceeding, okay?
Okay.
Okay.
But,
So you
just
also, I'm sorry, say it again?
Nothing, ma'am.
Yeah, okay. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
I think so, yeah.
Okay. And were you able to review the notice and the evidence submitted against you?
No, I haven't got the chance to review it. I just looked at it. Not really.
You just looked at it. Would you like time and a continuance to review the charges against you? We can bring you back at a later date if you need time to review everything.
No, ma'am. I'm trying to move forward. Trying
You're
to
ready
just
to
get
move
it out
forward?
the
Okay.
way. Yes, ma'am.
Okay. So the other rights you have at this are to submit any evidence upon your behalf. You also have the right to call and examine any witnesses or cross-examine adverse witnesses. So one more time, you're ready to move forward today after you understand these rights?
Yes, ma'am.
So we're now going to review the charges that the state, your parole officer, is bringing against you. Officer Davis, can you please read the charges and the underlying violation details for the charges that you have submitted, starting with charge number 1, condition of GPS?
Sure. Charge number 1, GPS. On 6/7/24, you were placed on GPS at initial intake due to previous noncompliance in the community. At this time, you were instructed on and agreed to properly charging your GPS unit for 2 hours daily. On the following dates, you failed to properly charge your GPS unit as instructed, resulting in your GPS unit shutting down. On 6/10/24, you allowed your GPS unit to shut down from 7:16 p.m. until 7:24 p.m., resulting in 8 minutes of your whereabouts in the community being unknown to this parole officer. On 6/14/24, you allowed your GPS unit to shut down from 3:54 p.m. until the next day, 6/15/24 at 1:45 p.m., resulting in 21 hours and 51 minutes of your whereabouts in the community being unknown to this parole officer. On 6/24/24, you allowed your GPS unit to shut down from 10:38 p.m. until the next day, 6/25/24 at 12:10 a.m., resulting in a 1 hour and 32 minutes of your whereabouts in the community being unknown to this parole officer. On 6/26/24, you allowed your GPS unit to shut down from 11:35 a.m. until 3:40 p.m., resulting in 4 hours and 35 minutes of your whereabouts in the community being unknown to this parole officer. On 7/5/24, you allowed your GPS unit to shut down from 6:53 p.m. until 9:19 p.m., resulting in 2 hours and 26 minutes of your whereabouts in the community being unknown to this parole officer. On 7/7/24, you allowed your GPS unit to shut down from 5:50 p.m. until 6:42 p.m., resulting 52 minutes of your whereabouts in the community being unknown to this parole officer. On 7/16/24, you allowed your GPS unit to shut down from 6:13 p.m. until 9:55 p.m., resulting in 3 hours and 42 minutes of your whereabouts in the community being unknown to this parole officer. On 7/19/24, you allowed your GPS unit to shut down from 10:07 a.m. until 6:23 p.m., resulting in 8 hours and 37 minutes of your whereabouts in the community being unknown to this parole officer. On 7/20/24, you allowed your GPS unit to shut down from 8:32 a.m. until 8:54 a.m. and from 11:17 p.m. until the next day, 7/21/24 at 1:14 a.m., resulting in 2 hours and 23 minutes of your whereabouts in the community being unknown to this parole officer. On 8/4/24, you allowed your GPS unit to shut down from 11:35 a.m. until 12:31 p.m., resulting in 56 minutes of your whereabouts in the community being unknown to this parole officer. On 10/3/24, you allowed your GPS unit to shut down from 4:14 a.m. until 9:45 p.m., resulting in 17 hours and 31 minutes of your whereabouts in the community being unknown to this parole officer. On 10/19/24, you allowed your GPS unit to shut down from 6:40 a.m. until 6:47 a.m. and from 9:30 p.m. until 9:49 p.m., resulting in 26 minutes of your whereabouts in the community being unknown to this parole officer. On 10/23/24, you allowed your GPS to shut down from 1:40 p.m. until 5:36 p.m., resulting in 3 hours and 56 minutes of your whereabouts in the community being unknown to this parole officer. On 12/10/24, you allowed your GPS unit to shut down from 10:42 p.m. until 10:47 p.m., resulting in 5 minutes of your whereabouts in the community being unknown to this parole officer. On 12/17/24, you allowed your GPS unit to shut down from 1:37 a.m. until 8:33 a.m., resulting in 6 hours and 56 minutes of your whereabouts in the community being unknown to this parole officer. This resulted in approximately 94 hours of accountability in the community with location unknown to this PO. On all occasions above, your whereabouts in the community were unknown to this PO, which is a violation of your signed GPS agreement. Charge number two.
Sorry, keep going. Sorry.
Oh, no worries. Charge number two, under obey all laws. Charge number two, obedience to the law. On 12/21/24 at approximately 6 p.m., you were arrested by the City of Groton Police Department. On the above date and time, you were seen exiting the parking lot of the Roadway Inn and traveling well above the posted speed limit of 25 miles per hour. The Roadway Inn is an area well known to law enforcement for narcotics trafficking and prostitution. At this time, a traffic stop was conducted. Before the arresting officer exited his cruiser, all three occupants in the vehicle, to include yourself, got out of the vehicle and began to walk away. You stated to the arresting officer that since you were already out of the vehicle, the officer was unable to pull you over. You were instructed to get back into the vehicle, but you refused to listen to verbal instructions and commands. During the stop, you continued to yell to responding officers, "You aren't searching my car." Your non-compliance with officers continued throughout the entire stop. Due to your behavior, you were subsequently arrested and charged with 14-215, illegal operation of a motor vehicle under suspension, 14-12A, failure to renew registration, 53A-167A, interfering with officer and resisting, and 12-218A, traveling unreasonably fast. Ultimately, you were issued a misdemeanor summons, MB 823605, with a court date of 1/3/25 at GA 10. You were released on a promise to appear. Charge number 3, notification of arrest. On 12/21/24 at approximately 7 p.m., you reached out to this officer that you had police contact. You failed to mention that you actually got arrested and pulled over by Groton Police Department. This PO gave you the opportunity to tell the truth during a reporting session, and you also failed to do so. This PO had to reach out to the Groton Police Department to get the details of what actually transpired. This is a violation of your signed parole agreement. 2, obey all laws. I will notify my parole officer within 48 hours of my arrest for any offense.
Thank you. You'll have the chance to speak to the charges. Just let me get through a few more things. You'll absolutely have an opportunity. Okay, Mr. Gardner? So I just wanna, yeah, absolutely. I just wanna identify the exhibits that have been submitted, by the state. I have remarked a few of them and have marked some of them. So I have Exhibit A, a remains actual custody order. Exhibit B, a statement of understanding and agreement conditions of parole. Exhibit C, the signed GPS agreement form. Exhibit D, the parole violation notice. Exhibit E, the parole violation report. Exhibit F, the parole, police report / misdemeanor summons and complaint. Exhibit G, the offender misconduct. Exhibit H, the decision information summary, DIS, and Exhibit I, the Allied Universal Reports. So just to confirm, Mr. Gardner, you have received the notice of parole violation, the parole violation report, and all the documents that have been listed as evidence?
I don't even know what that means. To be honest with you, I don't even know if I should continue this without the attorney, because it's starting to sound like a little bit too much. And not only that too, like my parole officer, David, said that he had reviewed the voicemail I left that night, and I told him
Mr.
that I
Gardner,
got pulled
but in
over.
a second, but listen, if you do want an attorney, I just want to stop you. Because anything you say, like, I just want to stop you. So are you invoking your right for an attorney for this process?
Yeah, I want an attorney now, to be honest with you, because this sounds a little loud. Is this going to be rescheduled like relatively fast, or does it usually get pushed out 30 days?
No, not 30 days. I'm going to try to get you on for Monday, the 24th. I have another, that's not the 24th, the 27th. Hold on. Whatever Monday is, Monday the 27th, I have another hearing. I can put you on for that day. Does that work for you, Mr. Officer Davis?
Say that again.
I'm going to reschedule his hearing. He's requesting an attorney. Are you available on January 27th for his hearing?
Yeah, that's fine.
That's okay. All right. So then I'm going to conclude this hearing as of today because Mr. Gardner has requested an attorney and representation, and then we will reschedule it for January 27th. Okay, so we are all set at this point. Officer Davis, I will just forward you the information when the final docket comes out, and we'll just call you down on Monday. Okay, Mr. Gardner?
Yes, thank you.
All right, thank you.
Have a good day.
You too.
Thank you.
This concludes the preliminary hearing for Mark Gardner, inmate number 374513. Hi, thank you.
All right, you're welcome.
Good morning, how are you?
We're still waiting for him to show up. He'll be here any second.
Okay, great, thank you.
Welcome. There, yes.
Officer Carrington, are you with us?
I am here.
Okay, great, so we can get started now. So I'm Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Kenneth Brown, inmate number 326008. Today's Tuesday, January 21st, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office at MacDougall Correctional Institution. Can you please state your full name and DOC inmate number for the record?
My name is Kenneth Brown. My inmate DOC inmate number is 326008.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. And present this morning is Attorney Sirica and Parole Officer Carrington. Attorney Sirica, can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Brown.
Thank you. And Officer Carrington, can you please identify yourself for the record?
Parole Officer Carrington with the Bridgeport Mental Health Unit.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Brown and Officer Carrington, can you both please raise your right hands? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
Yes.
Yes. So we're going to go over the procedure for the hearing. You can put your hand down, Mr. Brown. Thank you. First, I'm going to read your rights. Then I will review the parole violation charges that the state, your parole officer, is bringing against you. I will then review and identify the exhibits filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
So we're going to go over your rights for the hearing. So your first right is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to review the written notice of charges of violation. Did you receive the written notice, Mr. Brown?
Yes, I did.
Great. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes, I do.
So we're going to now review the charges that the state your parole officer is bringing against you and the information underlying each charge. Officer Carrington, can you please read the charges and the details under each violation, please?
Charge number 1 under drugs. On 5/6/24, you rendered a drug screen that was positive for cocaine. This was confirmed by a lab test. Charge number 2, halfway house placement. On 5/6/24, you submitted a drug screen that tested positive for cocaine. On 7/8/24, the program job developer at the halfway house reviewed your sign-out sheets and accountability forms from Emerge where you were working. It was determined that between the dates of 6/17/24 and 6/28/24, you were unaccountable in the community for a total of 32 hours, as it was verified that you were not at work at the times in which you were signed out to attend work. On 7/26/24, you were involved in a physical altercation with another resident while in the bathroom of the halfway house. As a result, you were moved to a different halfway house. On 8/3/24, you were observed on video footage yelling at another resident while appearing aggressive toward him, as evidenced by yelling and flaring your arms. Upon being separated, you were observed on video sitting in the television room with what appeared to be a combination lock and a sock. On 8/5/24, a search of your property in your bedroom was completed and a combination lock was located in your possession. As a result of having another altercation with a client, you were transferred to Isaiah Halfway House. On 8/21/24, you were transported by program staff to a mental health intake appointment at a treatment provider. You proceeded to leave the provider without permission and later returned. You did not have permission to leave the program and your whereabouts was unknown. On 9/21/24, staff smelled marijuana in the bathroom of the halfway house. Upon review of the security footage, you were the only one observed entering and exiting the bathroom at the time. You were also observed spraying cologne in the hallway outside of the bathroom shortly after. On 10/22/24, staff smelled marijuana in the bathroom of the hallway of the halfway house, Upon review of the security camera footage, you were the only one observed entering and exiting the bathroom at the time. On 10/31/24, you signed out of the halfway house program to attend work from 7 a.m. to 5 p.m. At 2:04 p.m., you were asked by the supervisor to clock out and leave the job site as a smell of marijuana and appeared to be under the influence. You did not inform staff that you left work. You failed to return to the program at the scheduled time of 5 p.m. You returned to the halfway house program at 8 p.m. You were unaccountable in the community from 2:04 p.m. to 8 p.m. and did not have permission from staff or PO to be in the community other than for employment. On 11/2/24, you were observed by staff exiting the bathroom. Staff smelled marijuana in the bathroom and on your person. You were the only person who had accessed the bathroom at this time. On 11/4/24, you returned to the halfway house and presented to staff as if you were under the influence. They requested that you render your analysis. After 3 hours, you went to submit an observed urinalysis with staff. You were observed to have a device or quote-unquote resonator on your person. You proceeded to come back to render hours later and had bleach on your hands. You then attempted to urinate on your fingers in which the bleach was on, while also urinating in the cup. This is evident of an attempt to tamper with your drug screen. On 11/5/24, you were unsuccessfully discharged from the Isaiah Halfway House.
Thank you. So I just want to put it on the record that the preliminary hearing charge number 2, condition of halfway house, was identified as 12 parts, and no finding was made for part 4 dated August 3rd, 2024. So that part was not taken into consideration at today's hearing. Also, the evidence submitted by the state was already identified as pre-marked at the preliminary hearing, so those all remain the same, and I have not received any new evidence from them at this point. So counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents?
We did.
Great. And I did receive an exhibit from this defense, which is exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Do you and your client need any time to submit any additional evidence?
No.
So today we have no witnesses, so it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So Officer Carrington, do you have anything that you'd like to state?
Nothing much more than what I had stated in the prelim. He has been issued various misconducts in all 3 halfway houses that he's been placed at since May of 2024 for continued substance use and repeated unaccountability while in the community on community passes. He's had a few altercations with other clients. He did successfully participate in the timeout program, which was in 2023. This is his first technical parole violation, and I'm just recommending a sanction of 5 to 6 months.
Thank you. And council, is now your opportunity.
Yes, we did previously conduct a preliminary hearing on November 25th of 2024. Obviously, no addendum is required. My client did not pick up any new charges. Just wanted to put comments that were put on a record regarding that charge number 2 for the July 8th of 2024. My client did indicate on the record he did go to work during that time frame. He was allowed to leave early during that time frame. Thus, the 32 hours apparently it's labeled as unaccountable. My client did put on a record that he did go to work on those days. For the July 26, 2024, Mr. Brown did dispute at the preliminary hearing that he had any issues with anyone at the halfway house. He did correctly put on a record on August 3rd, 2024. There was a no finding made on that. The August 5th of 2024, I know the preliminary hearing was probable cause. We're at the preponderance of the evidence standard. Regarding that combination lock, my client did put on a record that the lock did come with him from the DOC where he locked up his belongings in his room so no one would take his belongings. Regarding the August 21, 2024, at the mental health appointment, he did go. My client did put on a record. He did leave for a brief period of time to go get some food, but he did come back for the appointment. Just want to make that part of the record again. Once again, I believe it's number 11 regarding the November 4th, 2024 with the item that my client allegedly had. I know the halfway house staff member did put in there, but I didn't get any physical or picture evidence of the quote-unquote Wisdonator that my client had on his person. So he did dispute that at the preliminary hearing also. So being repetitive, but like I said, this is the same comments we made at the preliminary hearing. Thank you.
Thank you. Just want to take a moment and let you know my findings. So on charge number 1, I do find that you violated the condition of drugs based on the evidence in support of the charge, which is Exhibit A, D, E, F. Charge number 2, I am also finding that you violated the condition of halfway house placement based on the evidence of the charge, which is Exhibit A, B, F, G, H, I, J, K, and N. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. The purpose of this part of the revocation is to help determine what outcome I would recommend. So Officer Carrington, would you like to make any comments towards Mr. Brown's background and history?
Nothing that I didn't already say, just that this is his first parole violation, and just a recommendation of 5 to 6 months. And he'll have to be re-referred to a halfway house.
Thank you. Counsel, it is now your opportunity.
Yes, on behalf of Mr. Brown, my client is 38 years old. As previously indicated, he did successfully complete the timeout program previously. And he was at the Connection Halfway House program, looks like in 2023 in Uncasville. He did have a case manager there, Ms. Rank. He did complete the timeout program. He did report to us, he did receive his GED in 2012. And while at the Roger Sherman, he did receive his OSHA 10 certification through the Emerge, Connecticut, located in New Haven. He's indicated to us while at the Roger Sherman and Sarah Center, he worked part-time at Emerge, Connecticut, located in New Haven. He did various tasks, including construction, street sweeping, cleaning gutters, and painting. He's there for that position for approximately 6 months. While at the Isaiah House, he indicated to us he was full-time delivering for Martinetti liquor distributor. He was there for about 3 to 4 months, also a full-time job at Connecticut Distributors in Stratford. Was there for a couple of months also. And he just prior to his remand, he reported to us he had a position at Dollar Tree in Bridgeport, obviously never started that job. indicated to us while at the Cohegan House, he did participate in IOP. Also, it's like in May of 2024 to June, he did participate in IOP at MCCA in New Haven. He did have a clinician, Ms. Jackson, there. We did receive documentation that he was an active participant during a group discussion and also involved with Connecticut Community Addiction Recovery, CCAR, in New Haven. He also indicated to us he did volunteer at the Islamic Center Food Pantry in both Bridgeport and New Haven. I know Carrington indicated regarding his house, he's indicated to us he'd like to be sponsored by his mother. I'm not sure if he's been there in the past, if there's any issues, but I did provide you with an address and a phone number for Ms. McFadden, and the backup plan that Mr. Brown has indicated to my social worker was the connection reentry, the reach Bridgeport. He is considering return to school. He's interested in learning about commercial cleaning. And he is, he's indicated to us he might be able to go back to the distributors for a job. He also has a cousin who works up in the area in New Haven. So he does have some job prospects for when he's released, and he is amenable to any treatment recommendations put on him. Is that correct, Mr. Brown? Would I put it, just put it on the record?
Yes, but
Okay.
also I did the tier 2 program.
Okay, and that was, when was, you got the completion date on that, Kenneth? What's the date on it? You have the completion date?
On the 9th.
Okay, thank you.
Thank you.
Well,
Can I just add something? You guys had said he was full-time employed while he was in Bridgeport. He never obtained a full-time job. He went to work for one day at the liquor distributor and was asked to leave work after using marijuana.
Yeah, I
And
can
his
only.
mother, just so we know, his,
Kenneth,
I did
Kenneth,
speak.
let her speak.
I have
All right.
spoken to his mother a couple times over the past few months, and she is not willing to sponsor him, which is why he continues to end up in the halfway houses.
I can only report what he gives. If obviously, if the mother is not a willing sponsor, we'll go to Plan B.
Okay, so just skip it completely?
Yes,
You're okay with that, counsel?
if that's what she's indicating. I can't, like I said, I can only report what Mr. Brown tells my social worker.
Yeah.
But if I
I did.
take P.O. Carrington's word, if the mother does not want to be the sponsor, we have to put Plan B in place. I don't have a problem with that.
So we'll just do the Bridgeport location?
Correct.
Do you want?
He
wants to say something. Would you like me?
Upon the record, I do agree, this is, his first technical violation. The recommendation is somewhat in line. I am asking for a little bit, but he did not pick up any new charges while he was out. If my math is correct, he's out almost 9 months is what my records indicate. So he was out for a little bit of time. Thank you.
Thank you.
Can we just verify which district he would like for halfway house placement? I believe he had wanted New Haven rather than Bridgeport. I just want to make sure for his paperwork.
Mr. Brown, did you change that? I know this reporter who spoke to my social worker. Is it Bridgeport or New Haven? What's your first choice?
I would like to choose New Haven. New Haven or Bridgeport. But if I have to have a first, I'll put
New Haven first.
Okay.
Okay.
We'll put New Haven first, Bridgeport second, okay?
Yes.
Okay, thank you.
Yes.
Thank you. So I'm going to get to my recommendation. So I have listened to the testimony and I reviewed all the evidence, and I'm going to recommend that your parole will be revoked, Mr. Brown, and I'm going to recommend that you serve an approximate 4-month period of confinement as a sanction with the re-parole date of March 5th, 2025 with the following conditions: no alcoholic beverage consumption, no contact with the victim JK, a general no contact with Key Bank located at 201 Grand Ave in New Haven, mental health treatment, halfway house placement, And I think I do, Officer Carrington, I don't know if you can confirm behavioral management for anger management. He never completed that, did he?
Correct.
Okay, so also
did
the
not
behavioral
complete it.
management. Okay, so the behavioral management program for anger management as well. No sponsor. Okay, so that is my recommendation. I'm going to be forwarding it to the board on January 30th, 2025. You will receive written notice following that hearing date. And at that hearing, the board can do a few things. They can lessen my recommended sanction, they can or they can impose a sanction, or they can recommend to impose a sanction longer than what I want to, at which time a supplemental hearing will be held, where you'll be present to answer their concerns and questions about why they would want to keep you longer than that time, okay?
May
Does that
I,
make sense?
I'm sorry,
Yeah.
is it March 5th to be parole date? 4 months? I missed the March actual date.
Yeah, 4 months, March 5th,
Okay,
2025.
so Kenneth, it's going to the board on January 30th, which is a Thursday. If you can, call our office the next day, sometime on the 31st, after 11 o'clock. One of my secretaries can tell you over the telephone. If the board adopts the recommendation, you are on special parole. You have to be released on the March 5th date. You're going to get something in writing, but if you call my office the next day after 11 o'clock, we get an email. I don't have the written report yet, but we'll be able to tell you over the telephone, okay?
I understand what y'all saying.
Okay,
Understand.
good luck to you.
Great.
luck.
So
Thank
All
you.
right, thanks a lot.
Yep,
Thank
take
you,
care.
guys. Have a good day.
You too. Take care. 3260008. You're all set, Mr. Brown. Thank you for coming. I appreciate it.
All right. Thank you,
Have a good
Mrs.
day.
Ferraro.
Yep, take care.
All right, you too.